Welcome. I'm Robin Henry, head of the Commercial Disputes team here at Collyer Bristow.
And my name is Abby Coleman, an associate within our Commercial Disputes team.
In this podcast, we're going to discuss the topic of secret commissions, as customers, agents and third parties should all be aware of the common law duties that have developed around this subject in recent years. But before we start, Abby, would you mind doing a brief overview of commissions generally within the financial services sector?
Yes, of course. So commissions are commonplace within the financial services industry, particularly with broker arrangements. So a commission is a payment that the broker, as the middle party, receives for arranging the contract between the customer and principal. So brokers will usually be regarded as agents, which means they're what we call a fiduciary. Now, a fiduciary is someone who is undertaken to act for or on behalf of another, the principal, in relation to a particular matter, for example, brokering insurance or a mortgage for them, in circumstances which give rise to a relationship of trust and confidence. So the broker or agent has an obligation of loyalty to the principal who has instructed them, which means they cannot put themselves in a position where their duties and the principal's interests might conflict. Mortgage brokers, for example, cannot therefore act for two principals.
Absolutely. So it must follow from what you've said that an agent who receives payment from a third party for the arrangement without the informed consent of its principal would be in breach of its duty to avoid conflicts of interest. And until recently, that has been the basic premise of the common law regarding secret commissions.
And what actually qualifies as a secret commission?
Well, there are three requirements for a secret commission. These are, first, the payer must have made the payment to the agent of the principal. Secondly, the payer must have made that payment knowing the recipient had been acting as the agent of the principal. And third, the payments must not have been disclosed to the principal. Secret commissions can either be fully secret or half secret, depending on the level of disclosure by the agent to the principal.
So, for example, where a mortgage broker receives a commission from the lender without disclosing the existence of the commission at all to the borrower, the payment would be considered a fully secret commission?
Exactly. And an example of a half secret commission would be where a mortgage broker discloses to the borrower the fact that there may be a commission, but either doesn't confirm if one was paid or doesn't confirm the value. The commission would only not be secret at all where the mortgage broker discloses to the borrower the fact of and the amount of the commission it is due to receive from the lender. In that instance, the borrower would not be in breach of its fiduciary duty.
And in terms of remedies, which we will just touch on briefly, a secret commission is treated by the law as a form of civil bribery. This means the court is entitled to award alternative remedies against the payer and agent or broker, including restitutionary claims, for example, repayment of the commission itself, and or damages for fraud, so the loss suffered. The usual remedies for breach of fiduciary duties are also available when that is established, including rescission and compensation.
Thanks, Abby. Now, there have been some inconsistencies between judgments regarding secret commissions of late, but many of these were resolved by the March 2021 Court of Appeal case, Wood and Commercial First Business Ltd. And we can refer to this as the Wood case. The claimant in that case was an individual who took out 3 mortgages and a further advance from the defendant mortgage lender. All 3 mortgages were arranged through a mortgage broking company that received a commission from the defendant each time. The claimant later fell into arrears and commenced proceedings challenging the validity and enforceability of the mortgages on various grounds, including that of secret commissions. The claimant submitted that the mortgage broking company was her agent, and therefore the payment of a commission by the mortgage lender to her agent, without her knowledge, had amounted to a secret commission. The judge at first instance found the payments were fully secret commissions, as the claimant had received no written notice of the commissions. Interestingly, the judge held it was not necessary for a fiduciary relationship to exist between the claimant borrower and the broker in these circumstances, but the decision was appealed.
And on appeal, there were 3 questions to be determined. The first was whether a fiduciary relationship between the claimant and broker was a necessary precondition for granting relief. And the Court of Appeal concluded that in cases such as this, where an agent who provided advice, information or recommendations has received or been offered a secret commission, the courts do not need to conduct the complex analysis of the nature of fiduciary relationships. Instead, the question the court should ask is, did that agent owe a duty to be impartial and to give disinterested advice, information, or recommendations?
So that's a slightly lower bar than having to establish a fiduciary relationship. But there's a similar core concept, i.e. owing some kind of loyalty or impartiality, or at the very least, not acting against the interests of the client.
Yes, pretty much. There still has to be a certain type of relationship between the parties for a secret commission to be established, as you just described. Now, the second question on appeal was whether a fiduciary relationship existed between the claimant and the broker. Now, given the answer to question 1, instead of analysing the nature of fiduciary relationships, the court applied its new test and concluded that the broker was under a duty to make disinterested selection of mortgage products and put them to the claimant. Finally, the third question on appeal was whether the commissions that were paid should probably be categorised as half-secret commissions rather than fully secret commissions, as the Court of First Instance had determined. The Court of Appeal maintained that the commission was fully secret. The broker's terms and conditions had stated, we may receive fees from lenders with whom we place mortgages. Before we take out a mortgage, we will tell you the amount of the fee in writing. If the fee is less than $250, we will confirm we will receive up to this amount. If the fee is $250 or more, we will tell you the exact amount. Now, as there had been no such disclosure per that part of the terms and conditions, the only conclusion was that no commission was to be paid. And this is why the courts found that it was a fully secret commission. The appeal was therefore dismissed on all counts. But it is important to note that this case only considered fully secret and not half-secret commissions.
So to be successful in a half-secret commission claim, you would still need to establish a fiduciary relationship. But what is now clear from the Wood case is that it's not necessary for a fiduciary relationship to exist to find civil liability for the payment of fully secret commissions. The test to be applied for fully secret commissions is whether the agent was under a duty to provide advice or information on a disinterested basis.
Yes, so in other words, whether an agent is under a duty to be honest and impartial. It's also been referred to as the disinterested duty.
Exactly. And the consequence of this is that liability for payment of fully secret commissions can exist within a much wider range of relationships than was previously thought, which will potentially result in an increased number of court claims relating to secret commissions.
And this is expected even more so within certain financial sectors, thanks to recent judgments. For example, the motor finance industry. So in October 2024, very recently, the Court of Appeal handed down another landmark judgment in the cases of Johnson versus First Round Bank Limited, French versus First Round Bank Limited, and Hopcraft versus Close Brothers. For ease of this club class, we'll refer to them as Johnson, French, and Hopcraft. Now, all three cases had a similar fact pattern. The claimants had visited a motor dealership. The dealerships had assisted the claimants with entering credit agreements to obtain finance. The finance was provided by a third party, who in these cases were the defendants. The dealerships, therefore, had acted as an agent, and they all received commission from the defendant lenders. Now, the way the commission was calculated in each case was based on the interest rate the dealership had agreed with the claimant customer. So the higher the interest rate, the higher the commission.
Now, this already sounds concerning, as there's a conflict of interest there on the part of the dealerships. Convincing the customer to pay a higher interest rate, which isn't in the customer's interest, is incentivized by the dealership's personal remuneration through the commissions.
Absolutely, it's a classic red flag. Now, on the nature of the commission itself, whether it is secret or not, in Hopcraft, there was no mention of commissions at all within the paperwork. In Wrench, the terms and conditions under the heading General had said that a commission may be paid. And this is very similar in the Johnson case, where the possibility of a commission was also disclosed within a suitability document. So no mention of the commission in Hopcraft was very clearly a fully secret commission. As to the mention of a potential commission being buried in the terms and conditions, as it was in Wrench and Johnson, the Court of Appeal found that there had been no disclosure in any meaningful sense. So it was not enough to include the disclosure, to use the court's wording, in small print, which the lender knows the borrower is highly unlikely to read. Now, the further inclusion of reference to commission in the suitability document in the Johnson case was still not sufficient. It wasn't enough to inform the customer of all the material facts, such as the amount or method of calculating the commission or whether it would in fact be paid. So basically, some form of disclosure isn't enough to escape the fully secret category. Any disclosure has to be meaningful and give the customer all of the material facts.
So the days of burying reference to commissions in the terms and conditions are gone.
It seems so. And the Court of Appeal in Johnson Wrench and Hopcraft also confirmed the early decision of Wood in terms of the disinterested duty only being sufficient in the case of fully secret commissions. As the dealership was responsible for providing credit information to the customer and the customer's information to the lender in turn, this was sufficient to give rise to the disinterested duty. Now, had the customer been informed the dealership was not acting impartially, for example, by informing them that the commission existed and how it worked, the disinterested duty would be disapplied. In those circumstances, we'd be looking at either a half-secret or a non-secret commission, and the fiduciary duties would have to be considered to establish a claim. But to the extent the commission was fully secret, the disinterested duty applied and was sufficient to establish liability. Though it is important to note that in the case of fully secret commissions, a fiduciary duty, while not required, can still be found. A broker, for example, could therefore be found to owe both the disinterested duty and the fiduciary duties, and the available remedies would reflect both these findings.
So let's summarise. Now, these recent cases establish, first of all, in the case of fully secret commissions, fiduciary duties do not need to be established to bring a successful claim. Instead, it's the disinterested duty as set out by the Court of Appeal in Wood, which needs to be applied and would be sufficient. Though a fiduciary duty can also still be found to exist as well. Secondly, that disinterested duty isn't enough for half-secret commission claims. In those cases, it's still necessary to establish a fiduciary duty. And finally, the bar has been raised for disclosure transparency. Disclosure relating to commissions can't be buried in the small print and must be meaningful. Otherwise, commissions can still be found to be secret, and as such, the lower bar of the disinterested duty test can be sufficient.
All of those have been very helpful points of clarity, though we do have to note that the defendants in Johnson Wrench and Hopcraft were granted permission to appeal to the Supreme Court in December 2024. So we are now currently waiting for that hearing date to be fixed. But in the meantime, as we touched on, the widespread payment of brokers by means of commission, both in the financial and other sectors, we expect to see many more cases involving claims of secret and half-secret commissions coming out. The strong line that has been taken by the courts in this area and the variety of remedies available both against payers and recipients of commissions means that claimants may consider making a claim even when the amount of the commission itself is relatively small. It's very much a case of watch this space.
I couldn't agree more. Finally, we should mention that the FCA is carefully considering these recent decisions. It's said that, in their words, we are working closely with the financial services sector, Financial Ombudsman Service, and the government to understand any wider consequences and further steps. And that it is waiting for clarity on whether this is the court's final word on the issue. Back in January 2024, the FCA had introduced a pause on firms having to respond to complaints within the motor finance industry involving a discretionary commission arrangement, whilst it investigated the matter. As the recent Court of Appeal judgment relates to this work, this pause has now been extended until December 2025. And like us, the FCA is waiting for the listing date of the Supreme Court Appeal and ultimately its judgment. But until then, the law, as we've discussed in this podcast, stands.
So if you're listening to this podcast and are involved in a financial arrangement where commissions have or may have been paid, and you would like advice on the matter, please do reach out to our team here at Collyer Bristow. We'd be very happy to help.
Thank you very much for listening. Goodbye.